Welcome everyone to this webinar organized by Agora Dialogue. I'm Koukkides-Procopiou, and I've been asked by Agora Dialogue to facilitate a discussion between Dr. Klearchos Kyriakides and Professor Van Coufoudakis on what exactly happened in this informal 5+1 meeting at Geneva recently on the Cyprus problem. Dr. Kyriakides will be presenting his own position on the geopolitical and legal implications of the informal summit. And then Professor Coufoudakis will be sharing his thoughts on what Dr. Kyriakides has just presented to us. Of course, we will be opening the floor to questions from the audience. So please make sure you write your questions or your comments or suggestions to in the chat box, and I'll be happy to pass them on to the speakers. I will waste no more of your time and just go straight, give the floor to Dr. Kyriakides. Dr. Klearchos Kyriakides is the assistant professor and deputy head of the School of Law of the Cyprus campus of the University of Central Lancashire. I don't think he needs any more introduction. So Dr. Kyriakides, the floor is yours. Excited and enthusiastic to hear what you have to say on what happened very recently in Geneva.
Thank you very much, Anna, for that very kind introduction. I begin by thanking Agora Dialogue for inviting me to speak to you all this evening. I think it's also appropriate for me to thank everybody who's been involved behind the scenes in instigating this webinar. I had no idea what went on in Geneva. I was not there. I was not privy to any live stream from what was taking place behind closed doors. What unfolded in Geneva was a secret example of, I wouldn't even call it statecraft for reasons that we're going to discover in this presentation. It was an example of secret horse trading with a view to achieving an outcome or a non-outcome, and it appears that we've ended up with a non-outcome. So I'm going to offer some thoughts, purely personal thoughts. These are nothing to do with any organization with which I have or have had any relationship in the past. And my primary objective today, it's quite straightforward. It's to try and assess some of the geopolitical and legal implications of what the United Nations described as the, quote, informal 5+1 meeting on Cyprus. In parallel, I'm going to try and demystify what this rather peculiar and cumbersome form of words actually means, both geopolitically and legally. I stress that I can't cover all of the ground that I would wish. I'm going to, by and large, steer clear of the constitutional nuts and legal bolts of the so-called Cyprus problem, or the UK Turkey problem, as I normally call it these days. I'm going to be focusing on the geopolitical angle. And in that context, I'm going to be considering the subject from both the procedural as well as from the substantive perspective. On that note, I'm going to see if I can share the screen, or if Agora Dialogue can put these slides that if they don't work. See if we can, let me see if I can make this work. Just bear with me, please. If it doesn't work. I don't think it's going to work. Let me try again. Share screen. What about that? What can you see on the screen now, if I may ask?
Yes. Something. Oh, okay. Here we are. We've got your presentation on our screen.
Excellent. Excellent.
Great.
Okay. Right. Let's proceed. I'm going to go back into history. Today's webinar is taking place just a few days before the 76th anniversary of the unconditional surrender of Germany at the end of the Second World War on the 8th and 9th of May 1945. So we are conducting this webinar at a poignant moment of remembrance. In the years before 1945, which we must never forget, under the tyrannical regime of the Nazis, Germany had not only segregated its citizens into two communities formed of Aryans and non-Aryans, with genocidal consequences, of course. In addition, after launching one invasion after another, Germany occupied one sovereign state after another. And in the process, Germany engaged in one act of ethnic cleansing after another, and one act of colonization after another, together with one act of inhumanity after another. Thankfully, due to the combined efforts of the United States of America, the United Kingdom, and other allies on the Western Front, and of course the USSR and other allies on the Eastern Front, Germany was defeated, and a measure of post-war criminal justice was served by means of the war crimes trials held in Nuremberg. Another legal consequence was what you see on the screen, which was the formation of the United Nations Organization and the adoption on the 26th of June 1945 of the Charter of the United Nations. Its preamble reflects the revulsion that was felt in 1945 as to what had happened in the previous years during the Second World War and in the previous decades stretching back to the First World War. The United Nations Charter begins with the following words, which everybody around the world should be familiar with, but alas, is not. This is how the United Nations Charter begins. We, the peoples of the United Nations, determined to save succeeding generations from the scourge of war, which twice in our lifetime has brought untold sorrow to mankind, and to reaffirm faith in fundamental human rights, in the dignity and worth of the human person, in the equal rights of men and women, and of nations large and small, and to establish conditions under which justice and respect for the obligations arising from treaties and other sources of international law can be maintained. And against that backdrop, the Charter sets out a number of key provisions designed to maintain peace and security around the world and to promote other allied principles. On the day of the adoption of the Charter, President Harry S. Truman of the United States attended the conference in San Francisco where the United Nations was born. And he said, among other things, that the Charter of the United Nations is a declaration of great faith by the nations of the earth. Faith that war is not inevitable. Faith that peace can be maintained. Now, of course, those lofty words were not matched by concrete actions. Neither did the vision of self-determination that the 1945 generation had set out. But I'm saying all this by way of backdrop to what happened in Geneva. What occurred in 1945 was the creation of what I would call the post-1945 legal order. The adoption of the United Nations Charter in 1945 resulted in the adoption of a string of crucially important instruments of international law. The examples include the Geneva Conventions of 1949, the European Convention on Human Rights of 1950, the Hague Convention for the Protection of Cultural Property in Times of Conflict of 1954, and a string of conventions during the 1960s that reflected the antipathy of the world to apartheid as it was being practiced in South Africa and still in parts of the United States of America, although thanks to Presidents Kennedy and Johnson, segregation was rooted out by law through the Civil Rights Act of 1964, which was enacted in Washington shortly after the assassination of President Kennedy. Now, all that counted for nothing, really, in relation to the sovereign state that was established on the 16th of August 1960 in the eastern Mediterranean. That sovereign state was called the Republic of Cyprus. It was set up in extraordinary circumstances following what the British government has now decided to describe at the conclusion of a court case as a paramilitary campaign waged by AOKA. The upshot was the establishment of the Republic of Cyprus as an independent sovereign state, subject to severe constraints on its sovereignty, subject to the retention by the United Kingdom of two remnants of the British Crown colony of Cyprus dressed up as sovereign base areas. So the first partition, is very important to understand, the first partition of the island of Cyprus took place in 1960 with the retention by the United Kingdom of two colonial remnants. The constitution that was effectively a recipe for segregation and inequality and everything that flows from inequality, such as direct and indirect forms of discrimination, that led to a breakdown of constitutional order in 1963 and 1964, and the withdrawal of one of the so-called two communities that were created, or rather recognized, by the Constitution of 1960. And we ended up with an echo of the German invasion and occupation of France in 1940, which resulted in the zonalization of France with an occupied northern zone and a so-called free zone in the south, the unoccupied zone. It was never really free. It was in the pocket of the Germans, and eventually the Germans overran the unoccupied zone in 1942 in a follow-up to what was originally called Operation Attila. Turkey were influenced by that, it would appear, because they ended up invading and occupying and ethnically cleansing 36% of the north of the Republic of Cyprus in 1974, and they ended up creating what I understand is translated into English from Turkish as Phase Line Attila, the Attila Line, which was a name associated with the German occupation of France during the Second World War. Why am I mentioning all of this? I'm mentioning all of this because this is the backdrop to what we saw in Geneva over the last few days. This was an assault on the United Nations Charter, as was, we have to admit and accept, the coup engineered by the then junta in Athens in Nicosia on the 15th of July 1974. That gave rise to the first Turkish invasion on the 20th of July, and 3 weeks after the downfall of both the junta in Athens and its short-lived illegal regime in Nicosia on the 14th of August 1974. What did the United Nations do in response? In substance, the United Nations did nothing. Yes, they provided a measure of humanitarian aid. Yes, they adopted a number of toothless resolutions, but not under Chapter 7 of the UN Charter. And yes, the United Nations ensured that the United Nations peacekeeping force retained its presence in the Republic of Cyprus. But to all intents and purposes, the United Nations, under the direction, let's be frank, of a liar, Kurt Waldheim, Secretary General of the United Nations, former officer in Hitler's Wehrmacht, under the direction of Kurt Waldheim and under the direction of the 5 permanent members of the UN Security Council, Turkey was left to run riot and occupy and ethnically cleanse and echo what Nazi Germany had done in France in 1940 and in so many other places in the world. As a final prelude to what happened in Geneva, let me just read to you what President Harry S. Truman also said on the 26th of June 1945 when the UN Charter was adopted. The world must now use the UN Charter. If we fail to use it, we shall betray all those who have died in order that we might meet here in freedom and safety to create it. If we seek to use the Charter selfishly for the advantage of any one nation or any small group of nations, we shall be equally guilty of that betrayal. The job, he admitted, will tax the moral strength and fibre of us all. we all have to recognize, no matter how great our strength, that we must deny ourselves the license to do always as we please. No one nation, no regional group can or should expect any special privilege which harms any other nation. Well, those lofty words, which I have no doubt were sincere and sincerely expressed, counted for absolutely nothing, as did the UN Charter and the Geneva Conventions and the European Convention on Human Rights and all of the other instruments of post-1945, as and when Turkey invaded, occupied and ethnically cleansed the north of the Republic of Cyprus. And what we've had since 1974 is a so-called peace process designed to legalize the consequences of crude illegality and inhumanity and injustice. And that map that you see on the top right there is from the Annan Plan epoch of 2004, where, subject to so-called territorial adjustments, the two new states, or constituent states as they were called, were due to come into existence upon the entry of the Republic of Cyprus to the European Union in 2004. The Annan Plan died a death, and we've ended up with a further, what is it now, 17 years of, in inverted commas, negotiations to try to legalize the crude consequences of illegality, inhumanity, and injustice. No effort has been made by the United Nations to enforce the Charter through Chapter 7 of the UN Charter. They enforced the Charter, of course, when Iraq invaded Kuwait, quite rightly. They've enforced the Charter on other occasions in history, but for reasons to do with realpolitik and the role of Turkey in the international legal order, Turkey has been effectively left to its own devices in the occupied north of the Republic of Cyprus. And what we've seen under the Erdogan regime is the emergence of Neo-Ottomanism. That's a map that I found on the one of the websites of the Turkish government today. It's one of several you can find there that portrays the whole of the island of Cyprus, including the Republic of Cyprus and the two British sovereign base areas, as part of Turkey. It's a palpably false and misleading image, but it reflects the vision, I would suggest, of the Erdogan regime to rebuild the Ottoman Empire. And the map that's at the top there illustrates the Ottoman Empire at its height in 1878. Just one other image before we turn to Geneva. This is from the Ministry of Defense of Turkey. This was an image published on the 27th of February 2019. It depicts the official Turkish blue Homeland Doctrine. And yet again, here one sees the whole of the island of Cyprus, including the Republic of Cyprus and the two British sovereign base areas, as forming integral parts of Turkey. Palpably false, palpably misleading, yet Turkey has got away with it, in spite of what the United Nations Charter says, which obliges all members to refrain in their international relations from the threat or use of force against the territorial integrity or political independence of any state, or in any other manner inconsistent with the purposes of the UN. Well, I would suggest to the listeners, whoever's watching this presentation, that to portray a neighbouring sovereign state as part of your own sovereign state, contrary to international law, is, at the very least, contrary to the spirit of the UN Charter, and arguably contrary to the letter of Article 2.4 of the UN Charter. So all that is by way of backdrop to the, I would call it a pantomime, the pantomime that we've been seeing played out in Switzerland since 2017. Let's have a look at the wording. I'm going to engage a little bit of critical analysis of the wording. We had in 2017 the so-called Conference on Cyprus. Note, not the Conference on the Republic of Cyprus, the Republic of Cyprus being the official name of the official sovereign state that exists on the island of Cyprus. No, we didn't have the Conference on the Republic of Cyprus. We had the Conference on Cyprus. Cyprus being a nice example of constructive ambiguity. The word Cyprus can mean, if you want it to, the Republic of Cyprus. It can mean, if you wanted to, the island of Cyprus. So we had the conference in Cyprus, and as the UN admitted on the first day that it was held, it took place in the presence of the European Union. The European Union was present. It was an observer, but it was present. At the conference on Cyprus in 2017, the participants were, according to the British Foreign Office, the two leaders of the two communities and representatives of Greece, Turkey, and the United Kingdom as guarantor powers. Look at the difference with the pantomime we saw in Geneva last week between the 27th and the 29th of April 2021. The Foreign Office, the British Foreign Office, on that occasion didn't refer to the two leaders of the two communities, but to the leaders of the Greek Cypriots and Turkish Cypriots. Now, I'm no fan of the two communities, which I regard as structures of segregation that have taken the place of a unitary demos, which is the chief characteristic of a democracy. But I'm just making this point here that there has been a switch in terminology, a subtle switch in terminology from 2017, when the British were using the old terminology from the 50s, the two leaders of the two communities, to what we saw last week, when the British Foreign Office referred to the leaders of the Greek Cypriots and the Turkish Cypriots. This was a reflection, I would suggest, of British constructive ambiguity to please Turkey, that has moved away from the concept of two communities and has gone more firmly in the direction of two peoples. Instead of recognizing that there is one people in the island of Cyprus and thus the Republic of Cyprus, Turkey has adopted a view that it's actually been pushing for decades, but it's now adopted an enhanced form of this view. And the enhanced form of this view is that there are two separate peoples, in the plural, in the island of Cyprus. And of course, Turkey doesn't recognize the Republic of Cyprus. What didn't change from between 2017 and what we saw last week in Geneva was that the UK, Greece, and Turkey were present. They were there as guarantor powers. They weren't there in any other capacity. So Turkey didn't go to the Geneva meeting of last week as the occupying power of the north of the Republic of Cyprus. I mean, in a sense, it was ironic that a meeting held in Geneva did not expressly recognize that Turkey was an occupying power for the purposes of the Geneva Conventions of 1949. The United Nations, for decades now, has steadfastly refused to admit openly that Turkey is an occupying power. Thankfully, Resolution 550 of 1984 admits that there is, and it admits expressly that there is an occupied part of the Republic of Cyprus. So by necessary implication, the UN Security Council has recognized that there is an occupation and that Turkey is an occupying power. That's Resolution 550. The European Court of Human Rights, in a number of separate cases, has also accepted expressly that Turkey is an occupation of the north of the Republic of Cyprus. But last week, as occurred in 2017, the United Nations did not refer to Turkey as an occupying power. It referred to Turkey as a guarantor power. But of course, this is constructive ambiguity in action. Nobody on the British or the UN side went as far as to say, well, what are they guaranteeing? Under the 1960 Treaty of Guarantee, for all of its faults, there is a provision there obliging Greece, Turkey, and the United Kingdom to recognize and guarantee, if I remember the wording correctly, the territorial integrity and independence and security of the Republic of Cyprus. But that didn't happen last week. What happened last week was that Turkey attended as a guarantor power, full stop. Turkey did not attend as an occupying power. I've got to add one final point here. The United Kingdom did not attend as the colonial power in control of two remnants of the British Crown colony of Cyprus. Instead, the UK attended as a guarantor power. Now, this is all important because, but all this rather has an explanation. It's important because we've seen here the relegation of the Republic of Cyprus from the agenda. The Republic of Cyprus would not formally represented at this informal 5+1 meeting on Cyprus. The two communities, in inverted commas, that were these structures of segregation created by the Constitution of 1960 were present, although the Republic of Cyprus as such was not. Now that's the reality. What's the explanation? Well, I would suggest to you that the procedure that the United Nations has adopted is on all fours with what I termed the Macmillan Doctrine. In a string of lectures and articles I've written about the Macmillan Doctrine. My analysis is based upon what Harold Macmillan said in the House of Commons in 1958 and in 1959, and also with what he said in a number of declassified documents from the National Archives of the UK. But the essence of his philosophy as Prime Minister from 1957 till 1963 is encapsulated by what he said in the House of Commons at the close of the then conference on Cyprus, which resulted in the Lancaster House Agreement of the 19th of February 1959. This is what Harold Macmillan said on that fateful date. He said this in the evening as soon as the signatures had been applied. A conference on Cyprus began in London on the 17th of February 1959 with the participation not only of the three governments of Greece, Turkey and the UK, who were represented by their foreign ministers, but also of the Greek Cypriot and Turkish Cypriot communities, who were represented by Archbishop Klearchos and Dr. Koukkides, respectively. We have always maintained, and that to my mind has been the whole problem, that we would never settle this question except by a Turkish, Party 1, Greek, that's Greece, Party 2, British, Party 3, Greek Cypriot, Party 4, Turkish Cypriot, Party 5 agreement. That's the Macmillan Doctrine. The Macmillan Doctrine, as I understand it and as I have interpreted it, rests procedurally on the idea that the island of Cyprus must be in the hands of three states, Greece, Turkey and the United Kingdom, plus two communities. And that formula that Harold Macmillan expressed on the 19th of February 1959 was played out in Geneva. You had three foreign ministers of Greece, Turkey, and the United Kingdom in attendance with the representatives or leaders, as they're now called, of the two communities, or the Greek Cypriots and the Turkish Cypriots, as the British call them. Those are, by the way, labels that were popularized by the British in the 1950s. That's a story for another day. The only difference between 1959 and 2021 was that in 2021, the UN Secretary General was in the chair. Talking of chairs, we had this big fuss a month or so ago when Ursula von der Leyen, the President of the European Commission, went with President Michel, the President of the European Council, to meet President Erdogan in Ankara. And if you recall, Ursula von der Leyen, it appears because she was a woman, was denied a chair of sufficient grandeur. And as a result, President Michel and President Erdogan sat in two chairs of sufficient grandeur, and Ursula von der Leyen had to park herself on a sofa opposite the foreign minister of Turkey. The seating arrangements on that day illustrated the subordinate status of in diplomatic protocol of a foreign minister to a president. President, as I understand diplomatic protocol, is entitled to a more grand chair than a foreign minister. And yet, what do we see? What did we see in Geneva last week? We saw President Anastasiades of the Republic of Cyprus sitting in exactly the same type of chair as the three foreign ministers who were attending on behalf of their respective nations. So President Anastasiades didn't go as president. He wasn't portrayed as president. He was there in his purported communal capacity as leader of the Greek Cypriots, if we take the British formula of words, or leader of the Greek Cypriot community, if we take the UN's form of words. I've looked at the Constitution of the Republic of Cyprus. It's not very good. It's a recipe for segregation. But there's nothing in the Constitution of the Republic of Cyprus that recognizes any office known as leader, let alone leader of Greek Cypriots or Turkish Cypriots. So I asked the question, and I've been asking this question in writing, actually, in letters to various governments and to the UN, if I remember correctly, to the UN as well. none of whom have responded to me over the years, in which what is the legal and constitutional basis of the purported office of Greek Cypriot leader? What is the constitutional and legal basis of the purported office of Turkish Cypriot leader? Answers I have received, the answers I've received amount to zero, none. Nobody will answer that critical question. This is realpolitik in a sense. The Republic of Cyprus has been put in its place. It's being emasculated before our eyes. It's being re-Ottomanized in a sense, because instead of the United Nations promoting the concept of democracy, which rests on one integrated demos, people, singular, which recognizes the diversity of its citizens, which recognizes the different ethnic and religious backgrounds of its citizens, we've ended up with this monstrosity of a concept by communalism, which only recognizes Greek Cypriots and Turkish Cypriots, the phrase that we've been hearing ad nauseam for decades. Where are the citizens of the Republic of Cyprus in all of this? That phrase is missing from the lexicon. Where are the citizens of the Republic of Cyprus of Armenian background, or Latin background, or Maronite background, or British background, or Russian background, or Filipino background, or Sri Lankan background? Where are they in this picture? Where are all of the other citizens of the Republic of Cyprus who are not of the Muslim faith or the Greek Orthodox Christian faith, which are the two faiths expressly referred to in the Constitution of the Republic of Cyprus? Where are they in all of this? Well, I would suggest they're subject to a form of systemic racism, more clearly forms of systemic discrimination. They've been shut out of this process because only the Greek Cypriots and the Turkish Cypriots have been given seats around the table. Of course, this doesn't make sense unless you actually go back into history and trace the origins of these so-called two communities. Their origins lie in what the British colonial legislation called the Muslims and the non-Muslims. That's basically what it boils down to. That's why you end up with two communities. The Muslim community has been renamed the Turkish community under the 1960 Constitution, and the Greek community is the new name for what used to be the non-Muslim community. So what I'm going to suggest here is that geopolitically, what we've seen in Geneva is a triumph of Ottomanism and neo-Ottomanism, and a crushing procedural defeat, at least, for liberal democracy. The concept of two communities or two peoples has been allowed to be played out visually and verbally at this informal 5+1 meeting on Cyprus. And the concept of a unitary state has been tossed aside, as has the idea of a single integrated people, or demos, which is the abiding characteristic of democracy. To sum up, therefore, on this procedural side, with the aim or effect of implementing the Macmillan Doctrine and appeasing Turkey, this 5+1 format, two communities, three guarantor powers plus the UN, shuts out the EU. And that, I would suggest, is a geopolitical defeat for the EU. And it's a triumph for the UK and Turkey and the UK-Turkish alliance in the post-Brexit epoch. This is one of the first big diplomatic events of the post-Brexit epoch, and it's resulted in a win, a procedural win for the United Kingdom and Turkey. EU has been shut out of this whole picture. And I'll just make the point here that these people sitting around the table who are associated with the EU, and I'm referring here to His Excellency Mr. Anastasiades, as he was called by the UN, Foreign Minister Dendias of Greece. That's it, really. The occupation regime leader in the Turkish occupied north is supposed to uphold the EU law, but he's decided to align himself with Turkey. So the only two people around that table who were directly pinned to the EU were President Anastasiades, or His Excellency Mr. Anastasiades on the one hand, and Mr. Dendias on the other. So what you've seen here is, through Brexit, the EU representation around the Cyprus problem table has been reduced by one seat. And actually, the observer status of the EU has been snatched away from the EU. That's a big difference from the conference of 2017. I've already made the point that this 5+1 format camouflages the fact that Turkey is an occupying power in the north of the Republic, relegates the elected president of a sovereign state to a subordinate status. It cements bicommunal demographic segregation. It prepares the ground for a form of legalized bizonal segregation by the formation of either two constituent states, which is what Mr. Anastasiadis and Mr. Dendias were supporting, or a variation of that through two separate sovereign states, which is what Turkey and its apparatchik in the occupied area were calling for. But perhaps most significantly of all, this procedure that was adopted has humiliated the citizens of the Republic of Cyprus, but also the citizens of the 26 other member states of the European Union. And they are the human beings who matter in this equation, because they are the ones who have to live with whatever it is that these people operating behind closed doors are going to agree or not agree when they reconvene in 2 or 3 months, as the United Nations Secretary General has promised. Now, if I can just be given 5 or so more minutes, I'll just now turn my attention to some substantive consequences of the this informal 5+1 meeting, and I'll close. First substantive geopolitical consequences that the informal 5+1 meeting has underlined the undeniable geopolitical fact that since the exit of the UK from the European Union at 2300 hours Greenwich Mean Time on the 31st of January 2020, the free areas of the Republic, which is an EU member state, have found themselves sandwiched between separate territories controlled by non-EU members. So on that map that you're seeing at the top of the screen, we have there the Turkish occupied north of the Republic of Cyprus, which is de facto administered by an illegal entity known as the, in inverted commas, Turkish Republic of Northern Cyprus. That area is legally and constitutionally part of the sovereign territory of the Republic of Cyprus, but the Republic of Cyprus does not exercise effective control over that occupied area, and EU law is suspended over that area. We have then the UN-patrolled buffer zone, as the UN describes it. That's shaded in green. That's phase line Attila, if we adopt the Turkish terminology. In international law, what we see there are two ceasefire lines. It's not an internationally recognized border or frontier. That is a buffer zone which separates, or rather is formed by two parallel ceasefire lines. If you read the international media, you'll hear references to borders and frontiers. That's all misleading. Fake news, if I can use a phrase that's entered the lexicon in recent years, that's fake news. There's no such thing as an internationally recognized frontier or border across the Republic of Cyprus. What we have are two parallel ceasefire lines with the UN-controlled buffer zone in the middle, where the Republic does not exercise effective control, and EU law does not fully apply. EU law, however, does apply in the what is called the free areas, or perhaps it might be best to describe them, the non-Turkish occupied areas of the Republic of Cyprus. I don't think a sovereign state can be free if a substantial portion of its territory is occupied. So I think the non-occupied parts of the Republic of Cyprus, perhaps a better phrase. So the EU has some measure of influence there. But of course, now with Brexit, the EU has next to no influence over what happens in the United Kingdom, subject to the EU-UK withdrawal agreement and the EU-UK free trade agreement. And the sovereign base areas, even though they are loosely still tied to the EU, and they still have the euro as a de facto currency, to all intents and purposes, they are British colonial remnants that the British are in control of. So if one looks at the geopolitical picture on the island of Cyprus, that's to say the Republic of Cyprus plus the two sovereign-based areas, non-EU actors are now in control of substantial parts of the territory. Turkey, as a non-EU member, continues to control the majority of the coastline of the Republic. In fact, they occupy 57% of the coastline. The Republic of Cyprus, if you do the calculations, the Republic of Cyprus does not control a majority of the coastline of its own sovereign territory. The UK has its own coastline, as you can see in the two sovereign base areas. The legality of that arrangement, of course, is open to dispute, subject for another day. Remember, in addition to controlling this territory, the United Kingdom and Turkey, on the other hand, also control the airspace above the territory and the territorial sea off this territory. So geopolitically and therefore geostrategically, the EU has suffered a huge blow through the exit of the UK from the EU. Now, I have to just make a point here in parenthesis. I was brought up when I used to live in the United Kingdom in the Eurosceptic school of thinking, and I'm somewhat sympathetic to Brexit, but that's neither here nor there for the purpose of this discussion. What is important, though, is that the geostrategic and geopolitical picture on the island of Cyprus has undergone a substantial tilt away from the European Union and towards an emerging UK-Turkey axis, or perhaps I should say a reinvigorated UK-Turkish axis. And what we've seen at the informal 5+1 meeting on Cyprus in Geneva last week is the consolidation of this reinvigorated UK-Turkey relationship. I'm just going to look at my notes here and draw your attention to two very important agreements that confirm this. Here it is. On the 23rd of November 2011, the United Kingdom and Turkey signed a framework agreement on military cooperation, and that entered into force on the 11th of July 2018. That was in the pre-Brexit epoch. It has been followed by the 356-page free trade agreement entered into by the United Kingdom and Turkey on the 29th of December 2020. That was at the fag end of the post-Brexit transition period. That UK-Turkey free trade agreement was presented to the UK Parliament on the 24th of February 2021 and brought into force on 20th of April 2021, 1 week before the informal 5+1 meeting on Cyprus. And you'll see from the photographs that have been posted on Twitter and other social media by the UK and Turkish governments that Dominic Raab, the British Foreign Secretary, has a rather chummy relationship with Mr. Cavusoglu, the Foreign Minister of Turkey. On the 2nd of March 2020, Dominic Raab put the bilateral relationship in these terms: as NATO allies and G20 members, the UK and Turkey enjoy a partnership built on cooperation in defence, security and trade. And that bilateral relationship, which is built on cooperation in defence, security and trade, has inevitable consequences for the so-called Cyprus problem and the handling of the procedure that is associated with that so-called problem, or as I call it, the UK and Turkish problem, because these are the two last colonial hegemons of the island of Cyprus, and yet they've been given a front row seat. In fact, they're not been given a front row seat. They've been given the driving seat in this whole procedure. I'm going to just close with one final thought. I'm going to just make a declaration of interest here. I have roots into ethnically cleansed villages in the north of the Republic of Cyprus, in Nicosia and Bedra. I should have said that at the beginning. And that inevitably affects my approach to this. But it also makes me wonder why the United Kingdom, which was one of the victorious powers at the end of the Second World War, it was one of the builders of the post-1945 legal order. It was one of the countries that has given so much to the world through common law. I wonder why the United Kingdom has chosen to jump into bed so visibly with Turkey, and to prevent the post-1945 legal order from being applied in the Republic of Cyprus. But I really do wonder, and it grieves me that the United Kingdom has chosen to follow the policy that it has, particularly in the light of its noble role in support of the forces of freedom fighting the forces of evil during the Second World War. I'm going to just finish here with a thought. The informal 5+1 meeting in Cyprus does not alter the geopolitical reality that with active and sustained German assistance, Turkey has not only acquired S-400 missiles, but is also building a nuclear power station with 4 nuclear reactors, 110 kilometers to the north of Nicosia and 130 or 140 or so kilometers to the north of the 2 sovereign base areas of the United Kingdom on the southern coast of the island of Cyprus. Turkey, I would suggest, represents a threat to the United Kingdom, even though they're both NATO allies. And I asked the question, why was this nuclear power station not on the agenda in Geneva last week? Why is this nuclear power station under construction taboo? Why are so many people staying quiet about it? When we know, on the one hand, that Turkey has not signed up to a host of international treaties on nuclear safety and justice, and on the other hand, we know about the lessons of history from places such as Chernobyl and Fukushima. You see, one of the things that was wrong with that informal 5+1 meeting in Geneva last week was that it not only was seeking to legalize the consequences of illegality through some sort of deal struck behind closed doors, it also amounted to a form of denial. The parties, particularly the Western parties such as Greece and more specifically the United Kingdom, are in denial, I would suggest, that Turkey has inched towards Russia and towards other states that are hostile or are portrayed as hostile to the West. And this emerging civil nuclear program of Turkey is particularly worrying if one remembers what President Erdogan warned the UN General Assembly about on the 24th of September 2019. The possession of nuclear power should either be forbidden for all or permissible for everyone. Well, he's served notice on the West that he's decided to become close to Russia and less close to the West, but the West, it seems, has decided to let him have his cake and to eat it. So in conclusion, I'm just going to close with the following thought, which is that this webinar is taking place on the 76th anniversary of victory in Europe and the destruction of the odious Nazi German regime with all that it stood for. And yet, alas, the United Nations that was founded amid the ashes of Nazism has stood back and watched as segregation, invasion, occupation, ethnic cleansing, and other inhumanities have been inflicted on the southeast corner of Europe. The whole of humanity should sit back and sound the alarm. Thank you for listening.
Thank you, Dr. Kyriakides, for profound presentation of many points as food for thought. You've said, part of the charter is all nations, large and small, should be equal. So I think what you've just proved is that, some nations are more equal than others. It means, it seems, even under the auspices of the United Nations. And I think that the two other very important points among the many important points that were made were, of course, under what kind of constitutional mandate can the President of the Republic of Cyprus represent only one of the two communities in any kind of negotiations. I think that there's a constitutional vacuum of some sort. There is, I think we really need to think about the legalization of such, of what is going on. And you've raised some important points which have created a lot of question marks, I think, in many people, will create a lot of question marks in many people's minds. And I think that the last point you've made in terms of geopolitical realities, I mean, what an embarrassment to the European Union that it has been cornered away from its own strategic interests in the southern eastern tip of its territory, essentially, by two non-EU powers. And of course, I mean, the big question is, what is the EU? Who is the EU? Who is going to step in and be in the driving seat? So is it the Germans? Is it the French? Who exactly is this EU entity that we keep, consider as a geopolitical existence, as a reality? So I think these very basic questions were raised by you today. And of course, as a citizen now and not as an analyst, I'm extremely worried by the phrase that we've used repeatedly, behind closed doors. What will the day after entail for all of us who are citizens of the Republic of Cyprus, and how much power will we have actually in having a say in what will happen after any kind of agreement that takes place behind closed doors? So thank you very much for this very eloquent and detailed analysis of your personal understanding of what went on in Geneva very recently. And now I will pass the floor to Professor Van Coufoudakis. He's a Professor Emeritus of Political Science at Indiana University, and of course an expert and on the Cyprus problem for a very long period of time, and someone who loves Cyprus, if I'm allowed to use that phrase to describe you, Professor Coufoudakis. The floor is yours.
Thank you, Anna. Thank you for chairing this program today. And thank you, Klearchos, for your incisive discussion of legal and political issues affecting the Cyprus problem today. What I would like, let me just simply start very briefly on the issue of nuclear weapons that you talked about. The issue is not new. In 1998, I was involved in the movement that stopped the first Koukkides reactor in Turkey, thanks to the help of Canadian friends who realized that the reactor, the so-called reactor for peaceful purposes, that Turkey was attempting to acquire for Koukkides was not going to go to a seismic area of Turkey, therefore the Fukushima type problem, but at the same time, the reactor was what Pakistan used for its own nuclear weapons under the guise of peaceful uses of atomic energy. Now, Turkey has all the technical expertise from Pakistan. The relationship between Turkey and Pakistan is deep and long. We can discuss that someday. And more than that, at this point in time, it's getting help from Korea, South Korea, from Russia, and in the process, this time you'll see the functioning of the nuclear reactor within the next few years. Turkey plans to create about 20 nuclear reactors, peaceful reactors across Turkey. That's the long-term plan of of the government of Turkey. Now, Israel ought to be very alert about these developments because Israeli security will be affected greatly by a nuclear Turkey. We are only seeing the beginning of the problem now. We'll see the long-term effects of that down the road. Now, coming back to what happened in Geneva the other day. Why is anybody surprised? That's my very simple question. On the 10th of March, I gave a 1-hour-long interview to Greek radio and television, the international program of ERT from Athens, about the Cyprus problem, the upcoming talks and things like that. What we talked about basically happened in Geneva. Turkey came with a clear-cut agenda. Cyprus simply followed the traffic and unfortunately played the game that Turkey had worked out with the Secretary General. There was blackmail on the part of the Secretary General, who basically told us that in case of failure, he was going to re-examine his mandate to find a solution for the Cyprus problem. So all the burden was not on Turkey, who had made their positions very clear. They wanted to discuss the two-state model for Cyprus, despite of what the UN directives, the UN resolutions have been up until now. And another thing that we should never forget, Turkey has had long-term objectives and positions on Cyprus. In 1963, after the crisis in Cyprus, the constitutional crisis in Cyprus, Turkey basically said the Republic of Cyprus is defunct. What have we done? We have played along with that concept, and we have accepted essentially that the Republic of Cyprus is defunct because the Republic of Cyprus is never mentioned in any of the documents being exchanged in the negotiations all these years. The Republic of Cyprus is never presented as a participant. We have a community of Greeks, a community of Turkish Cypriots that now includes the settlers, the illegal settlers that are the majority of the occupied area's population. And more than that, we have accepted that the recognized president of the Republic of Cyprus is a Koukkides. He's a community leader. Turkey has achieved all that thanks to us. After the referendum of 2004, and I'm going to close with that, Cyprus, the people of Cyprus, for the first time had an opportunity to say no, and they did say no to the plans to destroy the Republic of Cyprus. The government, headed by Mr. Christofias first and Mr. Anastasiadis next, unfortunately has abandoned completely not only the outcome of the referendum of 2004, it has abandoned completely all the victories that Cyprus has scored in international courts, in international organizations about its status and about its membership in the European Union. Why am I mentioning this? Because it's easy to say, well, it was England's fault, Turkey's fault, whoever's fault. The fault is in Nicosia, that has accepted to negotiate under the terms that it has, and the end result today is what took place in Geneva a few days ago. Finally, now the Secretary General says he's going to find more private discussions with the so-called two parties to see how they can reconvene a five-party informal Geneva talk again in about 3 months from now. The pressure is going to be on the government of Cyprus to accept the two states that Turkey promotes right now. I'm not a prophet, but this is what is happening. Unfortunately, the government of Cyprus is playing the game demanded by Turkey. That's very sad. I'm not very optimistic about the future, but if we don't respect ourselves, don't expect others to respect you. Thanks. I cannot hear you.
Now you should. Can you hear me now? Yeah. Quite a sad note to end your summary of points, Professor Coufoudakis, but you've raised an important issue with what the Secretary General, the role of the Secretary General. And it's a question I want to pose to both of you. First and foremost, the Secretary General did not say outright to Turkey, we cannot have any talks under my auspices because my mandate by the Security Council is predetermined, is underpinned by a number of resolutions, which your proposal is totally divergent from. So we've never had the Secretary General say it clear, loud to the Turkish side, this is not acceptable, so we cannot be discussing things which are not under my mandate. And then, as Professor Coufoudakis actually described, there was some kind of blackmail of, well, if you don't find common ground, I may go back to the Security Council and change the mandate and so on and so forth. And it's the same argument we keep hearing to put pressure on us to say, the international community has grown tired of the Cyprus problem, and they put the pressure, as Professor Koukkides again said, on the weak side, because they know we're going to give in more easily than Turkey does. So obviously, to get any kind of result, they will put the pressure on us. So the question is, why is the Secretary General behaving in the way that he does? Who is pushing this kind of agenda for the Secretary General to fulfill? Because he's not representing himself. He is not representing Portugal, his nation state. He is representing the Security Council first, and of course, all the member states. So who is pushing this agenda? And why is the Secretary General not resisting, or why does he behave what is your 2 cents of wisdom on this? So shall I just give the floor to Professor Coufoudakis, and then Klearchos, I will give you the time to elaborate on what I've asked and maybe comment on what Professor Coufoudakis has also said.
Very simple in many ways. The Secretary General basically is coming to the end of his term, and he would like to have a solution of a long-term problem. They don't care what the solution is going to be like, because they're not going to be around to see the consequences of the solution they're putting together. So you can leave the UN and say, I solved X, Y, Z problems, thank you very much. And if the solution fails, it's not me, it's those people who could never make it work. That's what we heard over the London and Zurich agreements, and that's what we keep hearing ever since then. So he is listening to himself and his own political career, and the only thing he wants is a victory that I solved the problem. Nobody worries about the long-term consequences.
Clear.
I'm very cynical. I'm sorry. I'm very cynical.
Truth,
Yes,
the truth is usually cynical. So, Dr. Kyriakides, what do you think?
Well, thank you for that excellent question. The UN Secretary General is in a close working relationship with the United Nations Security Council. And for the past few decades, the so-called penholder of United Nations Security Council resolutions on Cyprus, as they call it, they don't call it the Republic of Cyprus, it is the United Kingdom. The United Kingdom is in the driving seat with the support of the United States, but also, it has to be said, with the tacit approval of Russia, China, and France, the other permanent members of the UN Security Council. All one has to do is look at the declassified documents that the CIA have published on its excellent Freedom of Information library website, and all the declassified documents that are in the National Archives of the UK and in other sources, to find that the core of the Cyprus problem, the UK Turkey problem, is the pursuit of segregation by the United Kingdom and Turkey, initially through two communities, and thereafter through the search for legalized zones. That was the idea from the late 1950s, but then Eisenhower administration was having none of it, as far as zones were concerned. But the Eisenhower administration accepted 2 communities, and hence we ended up with the so-called bicommunal Republic of Cyprus in 1960. And the search for zones continued after 1960. We ended up with de facto zones, the Turkish occupied zone in the north of the Republic and the non-Turkish occupied zone in the south, but those zones have operated on a de facto basis, and successive holders of the office of UN Secretary General have been doing the bidding of both Turkey and the United Kingdom in search of legalized zones. And it's utterly preposterous for a European democratic sovereign state to be carved up into separate, to have its population, its people carved up into separate communities owing their origins to Ottomanism. And it's even more preposterous for each community to be segregated into separate zones. I mean, this is apartheid. The Crime of Apartheid Convention of 1973 has not been signed by the Republic of Cyprus, nor by any of the other 3 parties to the 1960 treaties, the Greece, Turkey, and the United Kingdom. And the UN Secretary General has sat back and watched this and done nothing since the 70s. It's not just Mr. Guterres. We're talking about all of the successive holders of the office. They've sat back and become complicit in a search for a settlement which is based upon this British-Turkish idea from the late 50s. I have to say that if you look at the declassified transcript of the meeting between Jim Callaghan, the British Foreign Secretary, and Henry Kissinger, the American Secretary of State, on the 14th of August 1974, one sees a very cynical, you used the word earlier, cynical deal struck in secret. It was recorded in writing by the British Foreign Office, declassified in the National Archives of London, and published, believe it or not, by the Foreign Office in a book co-published with Routledge. And that secret deal effectively said, we are going to let the Turks take over the north of the Republic. We will have, in inverted commas, an exchange of populations, and we will then bring the UN Secretary General on board to try and come up with peace. And that was Jim Callaghan's proposal. Henry Kissinger endorsed it, and along came Kurt Waldheim to try to cook up a deal. And every single holder of the office of the Secretary General must know about that history that I've outlined. And if they don't know, they ought to know. And if they have a conscience, they shouldn't go along with it. But have a conscience and to operate in diplomacy, perhaps difficult bedfellows. So that's a rather longer answer to your question. But my simple answer is the successive holders of the office of Secretary General have sold their souls, and regrettably, humanity suffers. Because remember, whatever happens in one part of the world affects every other part of the world. Martin Luther King teaches us an injustice somewhere equals an injustice everywhere.
One thing I would like to add to this discussion, it is not just the Secretary General that has failed the terms of his mandate and the terms of the Charter. The European Union has failed in that sense too. We have the European Charter on Human Rights. We have the acquis communautaire that prohibits discrimination on the basis of ethnicity, race, religion, language, and all those wonderful things. But look at what is happening. If the new republic ever is created, it will be based on discrimination. It will be based on ethnic separation and principles that violate the fundamental principles on which the European Union is created. The solution, of course, that we hear from Brussels is very simple. Well, you have approved it, it's fine, we don't like, we'll make some adjustments to the acquis communautaire, a European law, and the adjustments come in the form of derogations that have been approved by the referendum that is going to take place in the Turkish side of Cyprus and the Greek Cypriot side. That's the whole story. And what people forget with all the initiatives of the UN, It was a key part of the Annan Plan in 2004 that was rejected by the Greek Cypriots. It is a key plan of the negotiations we have right now. What is that? It's the provision that once a settlement is approved by referenda between in the Greek Cypriot and Turkish Cypriot community, the outcome and the agreements cannot be challenged in the European Court of Human Rights as violating any principles of European law. The Annan Plan had that provision in it. They're insisting on it now, which means that essentially the solution violates fundamental principles of the EU, and Cypriots who are citizens of the EU will not be able to benefit from European law because they'll be prohibited access to European courts. That's the great danger.
So in essence, basically will be second-class citizens
Yes.
in the European Union, and we will not be allowed to appeal against decisions of our...
The position of the European Union is very simple. You voted for it, therefore you have accepted to limit some of your rights. People don't understand these things.
But then let me just pose the question to Dr. Kyriakides, who's a lawyer as well. So, I mean, can I negate my rights by signing any kind of agreement? Is that acceptable under, I mean, doesn't the law take precedent over any kind of agreement?
Well, we live
very simplistically, I'm not a lawyer, but as a citizen, this is what I would think.
We live in a different epoch to 2004. Back in 2004, the Republic of Cyprus was outside the European Union, and the aim back then was for the Republic of Cyprus to be replaced, to all intents and purposes, by the new state of affairs with the derogations that Professor Koukkides has outlined, and these acts of discrimination that would have been built in to the agreement. And EU law would have accommodated that, so that the settlement could be implemented, and so that the United Cyprus Republic, in practice can be a divided Cyprus Republic, but they called it United Cyprus Republic, so that the United Cyprus Republic can join the EU. The difference today in 2021 is that the Republic of Cyprus is already a member of the European Union. That means that there is a possibility, it may be remote, but there's a possibility of challenging the legality of any agreement, not only before the European Court of Human Rights, but more importantly, perhaps, before the Court of Justice of the European Union. I'm speculating here, and no doubt there are counter arguments to what I'm putting forward, but everybody in the Republic of Cyprus should be alive to the principle that nobody is above the law. That's what the rule of law is based upon, and that in 2021 we in the Republic of Cyprus, and I speak as a permanent resident now and as a UK citizen, we in the Republic have access to the local courts, and we have access through the local courts to the Court of Justice of the European Union in appropriate cases. The snag is that I understand it takes an awful long time for any court to hear any case in the Republic of Cyprus, because there's a backlog. I'm not a Cypriot lawyer, so I don't want to comment on the details of it all, but everybody in the Republic of Cyprus should at least have the reassurance in principle that whatever is cooked up behind closed doors is potentially open to challenging the courts. The downside is that if whatever is cooked up in secret is then enshrined in the UN Security Council resolution, the counter argument to my school of thought would be that, the UN Security Council resolutions prevail, and therefore there's no way that this can be challenged in court. I mean, just wait, one final point I'd make. The tragedy of the 1945 UN Charter, for all of its great strengths, is that it effectively prevented anybody from challenging, any human being, any citizen, any ordinary person, from challenging the legality of decisions taken by the UN Security Council, or indeed by the Secretary General of the United Nations. A lot of what the UN does is protected by immunity. And therefore that, in a sense, is one of the fundamental defects of the UN Charter. It does violate the rule of law in the sense that the UN Security Council is above the law. And there is a school of thought that suggests that a form of judicial review ought to be activated in the international sphere to enable citizens or potentially states to challenge the UN Security Council in the courts. Maybe Cyprus is going to be the test case that enables that to happen, but it requires strong leadership, which unfortunately is lacking in both Athens and Nicosia.
Because let me just post something, Professor Coufoudakis. Maybe you want to. I see you want to add something, but let me just post something. It's a question from the audience. They're asking if there's any way we can actually use the General Assembly as a means to coming to a more honorable, let's say, end or conclusion to the Cyprus problem. So what would you both think about that?
Very simple. The power to enforce decisions lies with the Security Council. We've had some very good resolutions through the General Assembly, but the enforcement power comes from the Security Council.
I would just add two brief points. The first is, yes, Professor Koukkides is absolutely right, but we do have the case of Mauritius that challenged the legality of the detachment, as the International Court of Justice called it, of the Chagos Islands from Mauritius prior to the establishment of Mauritius as an independent sovereign state. And that challenge went through the UN General Assembly and then through the UN General Assembly to the International Court of Justice, and an advisory opinion was issued which held that the United Kingdom was responsible for an unlawful detachment which precluded the proper application of the right to self-determination. So that's an example, a rare example of how the UN General Assembly has been. But that judgment, or it's not a judgment, it was an advisory opinion. That advisory opinion has not gone anywhere because the United Kingdom has not been subject to a Chapter 7 enforcement measure from the UN Security Council. And then if we tried to ask the UN Security Council to adopt a Chapter 7 measure to enforce that judgment or that advisory opinion, the UK has a veto in the UN Security Council. So there is the UN unfortunately has these inherent defects which were built into it back in 1945. The second brief footnote goes back to what you said, Anna, a little bit earlier about the inequality that the Republic of Cyprus has been subject to. I've just found the relevant provision in the United Nations, the main body of the UN Charter. It's Article 2.1. The UN, as an organization, is based on the principle of the sovereign equality of all its members. I repeat, the UN organization is based on the principle of the sovereign equality of all its members. Now, I just don't understand why successive governments of the Republic of Cyprus have not done what I've done and drawn the attention of the UN Secretary General and drawn the attention of the Security Council to that provision and insisted on its enforcement. What successive governments of the Republic of Cyprus have done is engage in a policy of appeasement coupled with a policy of throwing bits of international law into the bin to all intents and purposes. If the Republic of Cyprus is not going to pick up Article 2.1 of the UN Charter and ask for its application in practice, who is?
That's what I also have maintained all along, because we have abandoned all the wealth of the decisions by courts and international organizations that support the existence of the Republic of Cyprus, the rights of its citizens, and now we're helping to undermine all those decisions because we have thrown them in the wastebasket. Turkey is not at fault. We praise Turkey for having the foresight to see where the concessions are going to come from, and they know how to play the game.
I mean, obviously, even this thing with sovereign equality, it's quite, I mean, it's mad to be asked, what is your position on that? And have Cypriot politicians respond and, you know, say, I mean, I've heard all kind of nonsense, excuse my language, because sovereignty is about states. Citizens don't have sovereignty. Communities don't have sovereignty. So, I mean, why are we even engaging in a discussion about sovereignty? So, you know, it just goes out to show that there's a wrong mentality about handling this whole issue. And this brings me to another question, because I think we've covered most of the ground on questions posed by the audience, but I'm keeping two of them for the end. But since we've come to this point through the discussion, I'd like to ask both of you, in my mind, you know, observing decision-making procedures and processes, which is what I like to do when I do foreign policy analysis. I mean, the case of Cyprus is so much of an obvious case study for groupthink. You have a group of men, quite elderly men, I would say, in grey suits, sitting around a table behind closed doors, making decisions about everyone's future. So I've even, you know, I've written about it. I've said this is the Gray's Inn politics. You know, all lawyers with Gray's, barristers with Gray's Inn back in London, and these people have been handling the Cyprus problem in violation again of Resolution 1325, which says that there should be a gender-balanced approach when you're making these kind of decisions concerning peace and security. So you've mentioned leadership before. Do we stand any kind of chance, or will we just sleepwalk away to the, you know, away to the end of the cliff? We'll fall off, and then a few decades down the line, historians will be analyzing this and as another case study of groupthink. You know, tunnel vision, and, you know, walking your way to disaster with no devil's advocate to be actually given equal access in this decision-making process. Professor, would you like to start?
Klearchos, go ahead.
Yeah, one of my favorite books is by a sociologist called Diane Vaughan, who wrote about the space shuttle disasters. And she examined the concept of groupthink, and later NATO accepted that she was right in her analysis. Groupthink resulted in what she called the normalization of deviance, otherwise known as the normalization of deviant behavior. One of the reasons why the initial space shuttle disaster happened was because the NATO was getting away with it. Not NATO, NASA was getting away with it. The space shuttle was going up with these inherent problems and didn't crash the first time. Goes up the second time, didn't crash. It kept on going up without crashing, and then the groupthink took over. Oh, this is great. We're getting away with it in spite of problems, and until eventually the disaster struck, and tragically so many people lost their lives, and NATO was left humiliated. And the point is that groupthink is capable. This is not my school of thought. This is this great sociologist from the US, Diane Vaughan's school of thought. Groupthink is inherently capable of giving rise to deviant behavior, which thereby becomes normalized. And this is what we've had in the Republic of Cyprus. We've had the normalization of segregation. And thus, if one believes Martin Luther King, who said that segregation is evil, we've seen the normalization of evil. And all of these men in suits, with one or two female exceptions, all of these men in suits are not seeing what everyone with a brain can see, which is that they are peddling partition, peddling segregation, peddling the dismantlement of the post-1945 legal order. I mean, yet they've got away with it. Why have they got away with it? Because the people in power in the UN Security Council are tolerating the state of affairs. And the lesson of the space shuttle disaster is one day we are going to face a catastrophe. It may be through that nuclear power station that's been constructed 110 kilometers to the north of the Republic of Cyprus. I hope I'm wrong. It could be through another Turkish invasion and occupation of the Republic of Cyprus. It could be through some other calamity, but that's what history teaches. And prevention is better than cure. That's why people like me and other academics are speaking out, because we can see the dangers. We're aware of the lessons of history. We can see that the lessons of history are being disregarded. And we're using the only thing at our disposal, our mouths, our pens, and these days our computer, to try and send out the messages. That's all we can do. And I hope I'm wrong, but I do see that this normalization of deviant behavior leading towards catastrophe. I just hope I'm wrong.
Again, if there is a solution down the road, it eventually will have to go through another referendum, as it did in 2004. I hope the public is alert to what lies ahead and has a chance to understand that their future, the future of Cypriot Hellenism, is at stake. Now, in 2004, we were able to say no, a resounding no. Unfortunately, that resounding no has been forgotten, conveniently by the great powers and conveniently by the parties in Cyprus. And here we are again on the precipice, on the edge of the precipice, talking about what's going to happen and why are they doing what they're doing. If Cypriots do not protect their own integrity, their own existence, nobody else will. I'm a cynic. I'm the oldest one in the group here. I've seen the Cyprus problem evolve since the 1950s, and I've seen the ups and downs of the Cypriot case, whether at the UN, in the European fora, and so on. We have one more chance ahead of us to stop disaster from taking place. Don't expect others to help you if you're unwilling to help yourself.
I'm going to turn that last note on its head and ask you something that the audience has also been wondering about. But I'm going to phrase it a little bit differently. What if we don't come to a situation where we need to referenda to approve any comprehensive solution? What if we come to a point when there's an interim agreement, a strategic agreement, because this is what they were trying to achieve at Crans-Montana. I mean, Sper has said it publicly, and then we had it written in the Secretary General's report. And it was something that Turkish think tanks were sort of pushing for a few years back, before it was mentioned even at Crans-Montana. And I mean, I've had some long discussions with people and say, what is this thing, these bargaining over resources, coming to an intermediate agreement where you don't need referenda. So I will use Lloyd George's famous phrase for how they ended up getting into the First World War and that disaster. The country slithered into the cauldron of war. So I'm saying, will we slither into the cauldron of acknowledgement of an entity on the island? Because I've seen many documents from member states of the EU talking about two entities on the island. So we are there as far as acknowledgement of the existence of another state of affairs on the island, apart from the Republic of Cyprus. So the audience is asking, do you think Britain will be recognizing the so-called Turkish Republic of Northern Cyprus anytime soon? And I'm asking, what if not recognizing, but acknowledging even more, even further, its existence? And the second question posed by the audience again is, could there be a formula where you have this so-called Turkish Republic of Northern Cyprus as an entity being a sort of part or member or whatever affiliate of the EU without ever being recognized? So that again is a very dangerous state of affairs, because it will all, it's a lullaby to sleep for everyone, because we're saying there's no recognition, so no harm done. But I don't think that's true in my mind. So what do you think?
Well, on the issue of the interim agreement, this has come up over and over again. And even though interim agreements are not the final agreements that settle issues and things like that, they set the stage for what solutions are going to look like. And up until now, we have seen that with the confidence-building measures and all the concessions that have been made to facilitate the next round of talks. So, yes, there is a precedent that is dangerous to have opening statements that prescribe what the solutions are going to be like. It's dangerous to have commitments as to what the final outcome is going to be like. We have to be very careful on that. Remember, though, Turkey wants a referendum. Turkey does not want just simply the parliament.
Professor, we're losing you. The sound, we're losing. Could you just repeat what you've said? We couldn't hear anything.
Yes. What I'm saying is Turkey wants a referendum on the final agreement. The reason being that it confirms and affirms all the concessions done by the Greek Cypriot side. If you don't have a referendum that approves that, it's going to be very difficult later on to come back and say, well, you guys did it, you see. They want a referendum to confirm all these things, and there will be a referendum. Now, a lot of strange models are being put on the table. I heard the other day from a person from the Department of State, the Belgian model as a model of what can happen in Cyprus. Well, that's not a new idea. I met Rauf Denktash for the first time in occupied Cyprus in 1976 when I came there and crossed the line and all that. At that time, 1976, Rauf Denktash was talking about the Belgian model as something that can shape the future of Cyprus. We have seen how dangerous the Belgian model has been over the years. Belgium has held together simply because NATO is there and the EU headquarters are there, and the result is that they could not afford to have Belgium fall apart. Very simple. Belgian model is not going to work in Cyprus.
Yeah, I think the questions are very good. Models around the world are normally case specific. The first question was effectively an invitation to discuss the so-called Taiwanization of the so-called Cyprus problem, whereby there's sort of de facto recognition of the illegal occupation regime. And this can come about in a piecemeal way, which, to use the Lloyd George phrase, that slithers along. We mustn't forget the crux of the problem. The crux of the problem is segregation on a bicommunal basis. The segregation has been given geographical expression by means of an invasion in two phases, or two invasions, followed by ethnic cleansing, followed by illegal colonization of the occupied area, all of which has been affected in clear breach of Articles 147 as well as 49 of the Fourth Geneva Convention. We're dealing here with the consequences of crime. One of the things that those of us who are engaged in the public dialogue have to do, what we have to do is to try and change the landscape of the debate and the discussion and the dialogue. Agora Dialogue is a good mechanism for doing this. The occupied area is not just an occupied area, it's a crime scene. Why is it a crime scene? Because people have been forcibly evicted from their homes, contrary to the domestic law of the Republic of Cyprus and contrary to international law. By the same token, there are citizens of the Republic of Cyprus of Turkish background who've been forcibly evicted from their homes in Bafos district, Limassol district, and elsewhere, in pursuance of this grand strategy of achieving two separate and segregated zones. We're dealing here with a crime scene, and the crimes are not just limited to the 60s and the 70s. The annual US State Department reports on human trafficking from 2012 until 2019 refer to the occupied north of the Republic of Cyprus as a zone of impunity for human trafficking. So the colonization of the occupied area by colonists from Turkey has been supplemented with victims, the most vulnerable human beings on the planet, being trafficked into the occupied area, being sexually and otherwise exploited by brutal people, normally men, and the illegal regime is turning a blind eye to this, and to some extent, according to the annual US State Department reports, is actually complicit in this form of human trafficking. I cannot think of a more preposterous proposition than for the illegal occupation regime to be legalized either by stealth or overnight by means of a settlement. The crimes in the occupied area have to be clamped down upon through the robust enforcement of both the domestic law of the Republic of Cyprus and international humanitarian law and other forms of international law. That can only happen, in my judgment, through an independent war crimes tribunal. I've written about this in my articles in Greek. I'm going to sooner or later write about this in detail in English. We need an independent war crimes tribunal to address the crimes that have been inflicted upon the people of the Republic of Cyprus in the singular. We need to stop segregating through double referenda, as occurred in 2004. We need to stop segregating through the table arrangements that we saw in Geneva last week. And we need to stop segregating through the repeated use of these neo-colonial phrases that serve the interests of nobody other than the external powers that manufactured these phrases. I'm talking here about the two communities. We should be talking about the citizens of the Republic of Cyprus and the other lawful residents of the Republic of Cyprus. And those that are here illegally need to be treated humanely, but in accordance with the requirements of the law. So my point here, to sum up, is that Taiwanization is a disaster, because what it will mean is continued closing of eyes to manifest illegality of the most horrific kind. And I'll just invite everyone to pick up the annual US State Department reports on human trafficking. They're all published, and I invite them to read them. The Republic of Cyprus and its government does not come out with a clean record as a result of its record on human trafficking, but it has improved in recent years. The occupied area has not to any great extent. And I'm just troubled by the thought that the UN Security Council wants to legalize an illegal regime that is up to its neck in human trafficking and other forms of mass criminality flowing from gross violations of the UN, the Geneva Conventions of 1949. We need to change the way that we perceive the so-called Cyprus problem. It's a neo-colonial problem, and it's a problem that has been created by the infliction of mass forms of illegality, giving rise to inhumanity and injustice. And those forms of illegality, inhumanity, and injustice have been smothered with impunity, which is why the US State Department calls the occupied area a zone of impunity for human trafficking.
Thank you for your contributions to this discussion. We had some questions by the audience, which I think were duly covered by both of the speakers. But let me just ask one final thing. We've discussed a lot of things that are relevant to how the leadership should perceive the problem and how our leadership should persist on resolving this problem. But as active citizens, and since Agora Dialogue is a platform which encourages active citizenship and the discussion of many issues, not just the Cyprus problem, but issues that concern active citizens, if both of you would give one piece of advice to us today as active citizens of the Republic of Cyprus, what would that be? What can we do about it?
Go ahead. Go ahead, Claire.
Yes, first of all, before we close, I'd like to thank you, Anna, for chairing so well. I'd like to thank Van for his wise contributions, and everyone else who's been listening and taking part in the webinar. Thank you. The one piece of encouragement I would give to everyone in the audience and every citizen of the Republic and every lawful resident of the Republic is to do what democracy requires. What does democracy require? It requires citizens to behave like citizens. They need to comply with the law. They need to treat everybody else with respect and humanity, but they need to hold those in power to account through democratic forms of activity. That can involve letter writing, it can involve campaigning, it can involve taking part in elections, it can involve protests that are taking place lawfully. But the worst thing that can happen is for citizens to be docile and to sit back and do nothing. Citizens need to be proactive, and they need to try to change the landscape in which they're living. History shows that movements from the grassroots are capable of affecting change, but the grassroots have to coordinate themselves. The best example of that is the African American movement under Martin Luther King and others. They operated at an effective level through the courts, through street action, and through letter writing, and through articles, and through other mechanisms of action, democratic action. And they achieved change, which is lasting, through the Civil Rights Act of 1964 and other legislative measures. That's a history lesson that everybody should heed. So the one piece of advice I would give to everybody is to study the history of the US civil rights movement and how it managed to affect change in the 1950s and 60s. It's not a complete change, and there are still problems in the US, but that is the best case study I can offer. They took on the might of the Washington establishment, and they succeeded. And they did it honestly and honorably. And Martin Luther King should guide us as the future unfolds.
Just one closing comment on my part. A few days ago, Vassos Lissaridis passed away. Vassos fought for democratic ideals in Africa, in Europe, in Cyprus. We should not forget his memory. There are very few people of that stature, unfortunately, left with us today. The other thing is, respect the decision of 2004. The referendum was free, the referendum was democratic. Respect the decision of 2004. Don't fall victim to fantasies, to sophistries that are being circulated and paid for by outside sources. We know that the public stood up and won the day. Let's not destroy the heritage of 2004. At the end of the day, remember, whatever agreement, if an agreement is ever figured out, it's going to be very short in text. But like in the Annan Plan, beyond the Annan Plan, there were 9,000 pages of text, legal text, that had not been prepared by Cypriots, had been prepared by the technical staff of the UN and other people that were going to be the backbone of that agreement. So remember that behind the nice words about the bizonal, bicommunal federation and all those fantasies, those constitutional fantasies that we're talking about, there is much bigger reality behind it. The Annan Plan showed us that reality in the 9,000 pages that complemented that little troublesome plan that was going to divide Cyprus forever. Thank you very much.
Thank you, Professor. Thank you, Dr. Kyriakides. Of course, we need to thank Eva Ieridis, who is behind the scenes, and she's got the magic touch for making everything work on the technical side. And of course, Dinos Toumazos and Agora Dialogue for giving everybody the opportunity to listen to two esteemed speakers today and pose the questions. And as a final note, let's just remember who made voting compulsory. It was Solon in ancient Athens. Before instituting Sysakhtia, the shaking off of burdens for the citizens, which had enslaved half of the population, the poor, to the rich. And he said, when the city is in danger and the ship is unstable, the ship of state is unstable, every single citizen should take sides. because it's only by partaking in danger and the risks that you can partake into the privileges of being a citizen in a state. So I think this was also the message that both gentlemen tried to send to the audience today. And on this note, I close this discussion and looking forward to the many more discussions that Agora Dialogue has planned to take place in the next few days. Thank you, everyone, and have a lovely night. Have a lovely evening.
Thank you very much.